Yeah, I mean, I started practicing full-time healthcare law probably about 1990. I
Okay.
started practicing law in 1984, but I've always practiced healthcare law. My very first trial was a healthcare trial. So I tell
Got it.
everybody that I practice healthcare law now for 33 years.
Okay.
And
30.
in our firm, we have 18 attorneys. We exclusively practice healthcare law. That's it.
Got it. Okay.
Nothing other than healthcare law.
And joining us right now to give us the insight on this story with all these former NFL players, 10 of them being indicted by the federal government for healthcare fraud. And joining us now on the podcast, Ron Chapman. He is the founder and shareholder and CEO of Chapman Law Group, and he's been practicing healthcare law for 33 years. Ron, how are you?
I'm doing great. Thank you so much for inviting me, Mike.
Absolutely. I appreciate it. Let's start with this. So the Gene Upshaw NFL Player Health Reimbursement Account Plan. Can you explain to our audience what exactly this plan is?
Well, this was a tax-exempt plan that was set up by the NFL and the players' unions with the federal government in the sense of the federal government agreed not to tax it. So for the number of years that someone played in the NFL, they would be receiving credits up to a total of $350,000. And those credits could then be used for healthcare payments for themselves, their spouse, or their children tax-free.
Okay, that makes sense. Okay. So is this the kind of thing that it seems to me, Ron, like this is a pretty unique situation that was collectively bargained on behalf of the players and the owners to set up something like this where they can get this money tax-free.
Oh, this is very unique to do that. It's not unusual because ERISA allows for tax-free savings accounts for employers to do. So if you think of the NFL as the employer of the football players,
Yep.
then it's not that unusual. It's kind of like a healthcare savings account.
Okay, got it. And what is Cigna's role in all this? I know that they're the benefits administrator. What exactly does that mean?
They're just the person that supposedly tracks the beans. So example, they keep the money, they determine when the money's paid out and whether or not the documentation submitted by the player or the player's representative was sufficient to support medical necessity for whatever it is that they want, whether it's a knee brace or medical treatment, a medical bill, or a cryo chamber, or a hyperbolic chamber, whatever it is that they need.
Do regular people have access to accounts like this, or is this something, Ron, that's super unique to NFL players or maybe other kinds of athletes to set up this sort of plan?
I think the dollar volume of it is super unique to those types of individuals, athletes that arguably get hurt a lot or get hurt extensively and they need this type of thing. But anybody through their employer, even on their own, can set up a health savings account where they can contribute X amount of dollars based on their income into the account, and those funds then go in tax-free and come out tax-free.
When you say the dollar amount or the dollar value being high, what are we talking about here in this plan?
The maximum credit that you're allowed is $350,000. And you don't pay anything into it. It's based on a credit system based on the number of years you were in the NFL prior to and then after 2011.
Got it. And I think it was, if I'm correct, Ron, that it's 3 years. Once a player has 3 credited seasons, all of a sudden he has access to this account. Do I have that correct?
Yes, that's called a vesting period. Most people would know that in 401k plans or profit sharing plans in their employer. You have to be employed for 2 years or 1 year or 3 years before you can take advantage of the plan. In this case, in a sense, they had to be employed by the NFL for 3 seasons. They get credit for each season, and the third season, they get credit for all 3 seasons.
Okay, so let's go into these indictments of these 10 players and see what's going to happen. Well, let's go to the bottom line. How much trouble are these players in? Because you don't want the federal government going after you, I imagine.
No, you don't. And usually the federal government, when they obtain an indictment through a grand jury, they have a pretty good case. Not saying they have a bulletproof case, but they have a pretty good case. So starting out, the NFL players and the other people in the conspiracy are a long way behind the 8 ball, so to speak. They got a lot of catching up to do if they hope to win this. So when a case is brought, the charges, the evidence is pretty much there that the funds were paid out without a medical necessity.
That's one of the things I'm wondering, because with something like this, and I know in law, as someone who is now a licensed attorney in the state of Texas, I know law really operates in a gray area, but I'm looking at something like this, Ron, and it seems to me like this is black and white, in that either these guys were buying this medical equipment or they were not. It seems black and white. Is that right? Is that wrong? What do you think about that?
Well, to a layperson, and when I say layperson, somebody who's not a healthcare fraud criminal attorney, it kind of looks black and white. But when you peel off the onion, so to speak, and you get into the middle of it, it's not so black and white. The very first thing the government has to prove is there was no medical necessity. So to the extent they received any of the equipment or any of the care, the government has to prove that that care, that equipment was not medically necessary. So let's assume they jump over that hurdle. And in this case, the argument is most of these folks never received the equipment, never received the medical care. So the next thing is the government has to prove knowledge. Some of these NFL players I've heard, through and read in other newspapers and things, that some of them claim they had no knowledge of this. So the argument is that their account was used and some third person would submit these requests for authorization to Cigna and then receive the money on their own. Now, where the government comes in, the government says, well, hold on. Most of the players were paid between $2,000 and $6,000 for each of these false receipts or false claims or requests for benefits that were sent in. Now, whether that's true or not, I don't know, but that's the government's proof there. So if I were a player, the player has to prove that they had no knowledge of it. Now, the government holds a trump card here, and the trump card is something called deliberate ignorance. So the jury on knowledge will be given a jury instruction, and that jury instruction says basically that an individual can't remain so ignorant of the process so that later on they can claim that they didn't know anything about it. And so what the government's allowed to do is put in the facts and the circumstances. Like, well, when you received a check at home for $2,000 from ABC company, did you wonder where you got it from? Did you just deposit it? Well, I just spent it. I didn't know who it was from. That kind of thing, if it happened, is a good thing that goes to deliberate ignorance and can be used to prove circumstantially that you actually had knowledge of the scheme.
Okay, got it. So if I'm in a situation where I'm one of these players, and let's say, as I've seen, alleged in the indictments and also reading of the stories about this, that, somebody else is calling up and impersonating me, and okay, well, even though clearly I'm not getting the medical equipment, I still might be criminally liable because I'm getting those checks and I'm not, going and investigating how that's actually happening.
Well, that would be the argument, because they would argue that, you were deliberately ignorant of that, because this argument would be, look, nobody receives a check for $2,000 or $1,000 or $6,000 or multiple checks for $2,000 that doesn't at some point in time say, hey, what did I get this for? It's kind of like this. If you receive a refund check from the IRS for $50,000, and your income's only $20,000, you say, what the heck? This is a gift. And you cash it, well, you got a problem. Because anybody would have known that you weren't entitled to that $50,000 check.
That's a great way to put it. Can you explain, Ron, to our audience, tell us about federal sentencing guidelines and how they're going to play a factor in what's going to be coming up in this case?
Sure. There's a number of things that work into federal sentencing guidelines. The first thing is a base offense. So this is fraud. So the base offense here is 16 points. It could be 18, but I think it's 16 in this category. Okay. And that's the base offense for fraud, which is 2B1 in the sentencing guidelines. On top of that, you have to look at the loss amount. The loss amount is very critical, because the loss amount then adds additional points on top of that, anything from 4 all the way up to 20 or 30 points on top of that. And it goes based on the amounts. So for example, and I said 16, the base offense is 6, not 16. I apologize.
6, okay.
The base offense is 6. So what happens if you have a loss amount, let's say, of under $1 million, I think the additional points are 12. So now you have a factor of 18. And assuming you don't, I don't want to get too much of the weeds, you don't cooperate and get big credits for getting somebody else in trouble, you would then go to the guidelines and you'd go down the column and you'd look for 18 months or 18 points. And to the right of that, there's 7 columns. The first one is you've had no prior offenses. And it goes all the way to you're a career criminal. And then the judge would have to sentence you within those guidelines theoretically. And I say theoretically because a judge can go lower than those guidelines or higher than those guidelines with an explanation. And the explanation that most defendants look for is an argument that they cooperated with the government. It's called a 5K1, that they operated with the government, that they provided information that led to the arrest or conviction of somebody else, arguably that was involved in healthcare fraud worse than they were. And then typically the government will then ask the court to reduce the sentence by as much as 40%.
Okay, so do you think what's going to happen in this situation with these indictments, because there are 2 different indictments. One is against Karel Buckhalter and Carlos Rogers specifically. The other is against Robert McCune, John Eubanks, Tamarik Vanover, Clinton Portis, C.C. Brown, James Butler, Fred Bennett, and Etrick Pruitt. Do you think that's what's likely going to happen is we're going to have a number of these guys trying to testify against others? And it sounds like there were like 1 or 2 like real ringleaders of this specific scheme. So are we likely to see, let's say, 6 to 7 guys testifying and cooperating against the ringleaders in this situation?
Typically you will. You'll see a number of people that'll turn on some of the other folks. Now, the other thing in these indictments is they mention indicted and unindicted other co-conspirators.
Yes.
Which leads me to believe that there are other folks that the government may have indicted but not released the indictment, or they've decided not to indict them because they're turning state's evidence. Remember, these things come to light to the government usually on 2 circumstances. One is through the analytics of Cigna, they were able to identify the fraud because of the outliers, because too much money going out, too many cryo chambers being purchased or whatever the thing is, and then they can analyze it. The second way it comes out is somebody on the inside tells the government.
Okay, that makes sense. Bottom line, when you look at this, like, are we looking at a situation where some of these, bigger names, especially like Clinton Portis, could legitimately be facing actual time in prison?
Well, they will be facing actual time in prison unless they cooperate with the government to the extent that the government gives them a significant break and puts them on probation.
Okay.
Healthcare fraud is rampant in this country. The government estimates between $2.5 and $3 billion in healthcare fraud a year occurs in the United States. So the only way to combat that is they're starting to give stiffer sentences. Now, they're not stiff sentences in the sense you're going to go away to prison for 10 years usually, but you can expect to get 18 months, 2 years, 3 years, 4 years, and up for these kinds of things. And the fact that they're NFL players actually makes it more likely that they're going to get a higher sentence, because a lot of your lower level healthcare fraud criminals look at this and they say, hey, I defrauded TRICARE, which is a federal government program, out of $100,000 and I got 5 years. Why do these guys who defrauded 2 million, let's say, and they only get a year? And the government's cognizant of that. They have to make their sentencing make sense.
Okay. Ron, one general question I have about this matter, and tell me if this makes sense. Is this whole story unique in that it seems like the players are stealing from their own money? Is that a fair way to put it, or should I put it as somewhat differently?
Well, the way you stated it is kind of, it embodies the moral dilemma in healthcare. The moral dilemma in healthcare is this. The employer pays the bill, the medical doctor typically receives the benefit, and the individual could care less how much anything costs.
Yeah.
So they'll go out and get the most expensive stuff. They don't care if the person's reimbursed for 10 times or whatever. So in this case, there's no physicians involved, it looks like.
Yeah.
But so in this case, it's pretty standard. The employer's putting it in as a cost of employment, a healthcare benefit, and the employee saying, hey, I'm not sick. I think this money's mine. I want to get it out somehow. And so somebody develops this scheme so they can get it out without actually being sick. And what it does is it defeats the whole purpose for healthcare. I'm sure the NFL set this up because there are some NFL players that develop head injuries and other kinds of problems, and they legitimately needed the extra money to help them get extra equipment that a typical insurance company isn't going to buy you a cryo chamber. They're not going to buy you a hyperbolic chamber to put in your house.
That's right. That would be extremely surprising. So let's say these allegations are true. This fund, the Gene Upshaw NFL Player Health Reimbursement Account Plan, it's a tax-free fund, and we talked about it a little bit earlier. So the money that goes in is tax-free. The money that comes out is tax-free, which, as anybody knows, is incredibly rare in the United States of America. Let's say these allegations are true. These allegations in the indictment. Is the tax-exempt status of this plan now going to be in jeopardy for all the other retired NFL players?
It would be. Now, I'm not a tax attorney, but I do understand that to have this particular benefit, the payouts, the funds that are going to reimburse the players, whoever, have to be used for legitimate medical purposes. So if the medical necessity and the actual delivery of the durable medical equipment or service, whatever, is not actually delivered, and cash is paid out to people, that thwarts the actual purpose of the plan. And if the government finds that that's enough to remove its tax-exempt status, then it would do that. And the government does do that on a regular basis. It doesn't make the front page news, but a lot of tax-exempt plans, a lot of tax-exempt organizations, on any given month, any given year, their tax-exempt status is taken away because of a variety of things like this. The funds weren't used for the purpose for which they were tax-exempt.
Is there anything else I haven't asked you, Ron, that you would like to add about this story at this point?
Well, I guess the sad truth is this story really isn't as unique as people think, in that healthcare fraud is rampant. It's everything from the local physician that overbills intentionally to get a little extra $20 or $30, to marketers that call you up on the phone and talk you into buying pain cream at $7,000 a tube, which you don't really need, or DME equipment. So the federal government, they don't have unlimited resources, but the resources they do have, they go after these kinds of schemes. And when they identify them and decide to put their weight behind them, they go at them strong. I would bet that some people here, I don't know about everybody, but some people are actually going to do real hard prison time over this event. The other thing to talk about is the forfeiture. So they will have to forfeit any profits, any proceeds of this. And if it's commingled with other monies, maybe they're going to have to, give up that money too, plus the fines on top of this. So typically the government's not only going to give jail time, but if these folks are wealthy, the government's going to get back significant more than they spent out to give to Cigna and reimburse their account.
So we could be looking at jail, forfeiture, and fines. Obviously, a lot to look at when it comes to these indictments and what's going to happen over the next few months and the next few years as well. He is Ron Chapman. He is the founding shareholder and the CEO of Chapman Law Group. He is an expert in all these matters. He has practiced healthcare law for the last 33 years. Ron, thank you so much for joining me on the Mike Meltser podcast.
Thank you, Mike. Have a great day.
Thank you so much, Ron. That was great. I really, really appreciate it.
Thank you. I enjoyed myself.
Absolutely.
Call me anytime.
Sounds good. Thank you so much, man.
Bye.
Thank you.